Do you ever feel like you're just drowning in information sometimes? Especially when you're trying to get your head around really big ideas like what is law, actually? Or justice? Where do these things even come from?
Absolutely. It can be totally overwhelming.
Yeah, and that feeling is exactly why we do the deep dive. We take source material, could be research, articles, historical texts, and we really try to pull out the core insights, the key facts, and just bring them straight to you.
Kind of a shortcut, guided by what the sources actually say.
Exactly. And today we are taking a deep dive into some, well, foundational and potentially pretty challenging stuff. Excerpts from Natural Law. It's by Lysander Spooner. He was a 19th century American abolitionist, legal theorist, essayist. Quite a figure.
And these texts, they lay out a very specific and you could say radical view on justice, what he calls natural law. And he draws this incredibly sharp contrast between that and, well, human legislation.
Right. So our mission for this deep dive is pretty clear. Based only on this material we have, we're going to unpack Spooner's core arguments. We want to get his definitions, follow his historical points, and basically see law and government through his, let's say, unique lens.
It's definitely a unique lens.
It is. So, yeah, buckle up because we're about to explore some ideas that, look, even if you end up disagreeing with them, they might just make you think about law and justice in a totally new way.
Worth grappling with, for sure.
Okay, so let's unpack this, starting right at the foundation. Spooner's definition of justice. What does he say it is, according to these texts?
Right. So according to these excerpts, Spooner defines justice very, very specifically. He calls it the science of mine and thine. And he immediately links this science, this mine and thine, to the science of all human rights. He explicitly mentions life, liberty, person, and property.
Okay, mine and thine. So it's essentially about defining those clear boundaries, our rights versus others' rights.
Exactly that. He says it's the science that tells anyone, any person, what they can and cannot do or have or even say without stepping on someone else's rights. And interestingly, he frames it right here as the science of peace.
The science of peace. That's a striking way to put it. How does he connect justice and peace so directly here?
Well, the source lays out two really simple conditions. He says these are the only conditions needed for mankind to live in peace. First, each person has to do towards every other person everything that justice requires them to do.
Like what? What kind of things?
He gives practical examples. Paying your debts, returning property you stole, making reparations if you've injured someone. Basic stuff, really.
Okay, that's condition one. What's the second?
The second is that each person must abstain, must not do anything to another person that justice forbids. Again, familiar examples. Yeah. Theft, murder, arson, any crime against a person or their property.
And if those two simple conditions aren't met, what happens then, according to him?
He's very blunt about it. The source says they are then at war. Simple as that. And they have to remain at war until justice is somehow put back in place.
Wow, okay. He also brings up an ancient maxim and a universal obligation. What's he referring to there in these passages?
Yeah, he points out that historically, wherever people tried to live peacefully, their sort of natural instincts and collective wisdom led them to acknowledge this universal obligation. Essentially, that each should live honestly towards every other.
Live honestly.
Right, and the ancient maxim he quotes is, to live honestly, to hurt no one, to give to everyone his due. But then he clarifies that, really, just to live honestly pretty much covers the whole thing.
Gotcha. Now, there's a distinction he makes that feels really important between legal duties and moral duties. Can you break that down as he presents it?
Yes, this is absolutely key for understanding his whole argument later on. He says, look, people owe lots of moral duties to each other. Things like, feeding the hungry, clothing the naked, sheltering the homeless, helping the sick, all those things.
Acts of charity, basically.
Exactly. He says these are duties where each person must be their own judge in every single case about whether they'll do it, how they'll do it, how much they'll do. It's voluntary. Compassion, benevolence.
But legal duty is different.
Completely different, according to this text. That duty, the duty to live honestly, based on this science of mine and thine, is something others can judge. And not just can, he says, but for their own protection, they must judge if someone's fulfilling it.
And they can enforce it.
Yes. And here's the crucial bit. They may rightfully compel him to perform it. He says this compulsion can happen individually, or people can band together, do it immediately, or set up systems. So justice isn't optional charity. It's a compelled obligation.
Okay, so justice is this fundamental, compellable duty. Where does it actually come from then? Did we humans invent it, or is it something else?
The source material is incredibly clear, very emphatic on this. Justice, he says, is of necessity a natural principle.
Hmm.
If it's not natural, the text argues, it's not real. It's just a fantasy, a non-entity. It basically doesn't exist if it's not part of nature itself.
And if it is a natural principle,
Then, according to this text, it logically follows that it must be an immutable one. It cannot change, ever. He compares it straight up to things like the law of gravitation or the laws of light or mathematical principles. Immutable. Justice, he says, can no more be changed by any power inferior to that which established it.
so human laws legislation, they literally cannot alter this natural justice. Is that what he's saying?
That's exactly what he's saying in this text. Absolutely not. Any attempt, any assumption by any person or group, even if they call themselves a government, to put their own rules, their own will, their own pleasure or discretion in place of actual justice. He calls that an absurdity, an usurpation, and a tyranny.
Strong words.
Very. And he really hammers this home later on, saying any legislation that tries to add to justice or take away from it is false, absurd, and ridiculous. It has, he claims, no more obligation than the idle wind.
Wow. Okay. He also makes this pretty notable claim that this natural justice is actually easy to learn. How does he justify that, especially when law seems so complicated to us?
Yeah, it seems counterintuitive, right? But he describes honesty, justice, natural law as a very plain and simple matter, easily understood by common minds. Okay. The source argues that people just learn it naturally through their everyday lives, their interactions, demanding what you think is yours, resisting when someone tries to violate your rights. He claims that pretty much everyone has the same basic understanding of justice once they know the facts of a situation.
He even uses that example about children learning it really early on.
Yes, exactly. It's a powerful example. He talks about how kids grasp fundamental principles of natural law very young. Things like don't hurt others without a good reason, don't just take control over someone else, don't take stuff by force or sneakily.
Right.
And he argues they learn these things, and even the idea that you should help someone who's been wronged before they even learn words like justice. It's like learning about hot and cold before you know the words hot and cold.
I see. So the example reinforces the idea that justice is intuitive, inherent, not some complex thing lawyers invent.
Precisely. That's the point he's making with that.
So if justice is this natural, inherent, immutable, easily understood principle, what does the source say this means for our rights as human beings?
Well, he connects it directly. If justice exists as this natural principle, then it is the principle that defines the rights given to every human being at his birth.
Oh.
These rights, person, property, are presented as just inherent. They necessarily remain with him during life. They can't be blotted out, extinguished, annihilated, or somehow separated from a person's nature.
And the flip side?
The flip side, the text argues very starkly, is that if there is no such natural principle of justice, then people are born without any rights at all, and they must stay that way forever.
Okay, that's quite a framing. And what's really interesting is how he then links this directly to politics and government.
Yeah, this is where it gets really political. He states, flat out, that if justice is a natural principle, then it is necessarily the only political principle there ever was or ever will be, full stop. All other so-called political principles people invent. He dismisses them in the text as mere conceits of simpletons or mere devices and pretenses used by selfish people to grab fame, power, and money.
So justice is the only real political principle.
According to Spooner in this text, yes.
And what if there isn't this simple natural science of justice he's describing?
Then the source argues there can't be any science of government either. It's impossible. And in that case, the historical pattern we see, a few confederated villains using violence and greed to dominate everyone else, forcing them into poverty and slavery, and setting up these things they call governments just to keep people down. Well, the text presents that pattern as the only kind of government you could logically expect to find if natural justice isn't real.
Okay, this definitely leads to the big question that seems to hang over everything he's said so far. If natural law, this justice, is so clear, so necessary, so easily learned, why doesn't it just prevail everywhere? Why do we even have human legislation at all?
Right. That's the obvious puzzle his argument creates. And the source provides a very pointed and radical historical explanation for why we have legislation instead. It argues that human legislation, basically everywhere people moved beyond a savage state, didn't come from reason or justice. It came from groups who, according to the text, associated and organized themselves as robbers to plunder and enslave all others.
Robbers. Seriously. So Spooner's claim in this text is that governments fundamentally started out as, like, organized crime.
According to this text, yes. That is exactly the origin story presented for government and legislation. He describes these groups getting stronger by banding together, making better weapons, training themselves, and then dividing up the loot and the captives.
And they succeeded
Because the text says the people they were attacking were mostly scattered, peaceful, defenseless farmers, just trying to work the land. Their only option, the source claims, was to give up their property and basically become slaves.
Okay. And how did this develop further?
Well, he continues by describing how these original tyrants, who lived entirely off this plunder and slave labor, grew bigger, extended their conquests. But to keep control over this large enslaved population, they realized, according to the text, they needed to be more systematic, cooperate better amongst themselves.
And that's where government comes in.
That's where he says they established what they called a government and started making what they called laws.
So the source is claiming these first governments and laws were basically just internal agreements between these robbers to manage their spoils.
Precisely. He states it very, very directly. All the great governments of the world have been of this character. He calls them mere bands of robbers who have associated for purposes of plunder, conquest, and the enslavement of their fellow men. And their laws, he argues, as they have called them, have been only such agreements as they have found it necessary to enter into, in plundering and enslaving others. And then he adds that these laws have no more real obligation than have the agreements which brigands, bandits, and pirates find it necessary to enter into. That is quite the claim.
That's putting it mildly. And he says substantially all the legislation of the world came about this way.
Yes, that's the incredibly strong historical claim made right here in the material, that legislation originated in the desires of one class of persons to plunder and enslave others and hold them as property.
Okay, so that's his historical argument about the origins. How does this perspective, as laid out in the source, connect to legislation later on, maybe closer to our time? Does he see that pattern continuing?
He does describe a kind of transition. The original robber class, or slaveholding class, having grabbed all the land and the means of producing wealth, eventually figured something out. They realized that sometimes the easiest way to manage and profit from the people they controlled wasn't necessarily keeping them as direct chattel slaves. It was often more convenient, he says, to give them some appearance of liberty. But, and this is the absolute crucial point in the text, they kept firm control over the land and all the ways to make wealth.
So these people weren't actually free then, in his view?
Not really. The text explicitly calls them, erroneously called, liberated slaves. Why? Because they owned nothing. No land, no tools, nothing. So they were compelled, according to the source, to sell their labor back to the landholding class, basically, their former masters, just to survive. Often for bare subsistence wages, sometimes not even enough for that.
So still dependent, still controlled.
Very much so. The source says they were scarcely less enslaved than before, and actually their survival was more precarious. They could be easily thrown out of work, left with nothing. This led many, the text says, to begging or stealing or starving. And this situation, Spooner argues here, made these landless poor people dangerous to the property and safety of their former masters.
And that led to more government and laws.
Exactly. According to Spooner here, this perceived danger led the landholding property class to organize themselves more formally, more perfectly, as a government. And they started making laws specifically designed, he claims, for keeping these dangerous people in subjection.
Laws like, say, fixing the price of labor to keep wages down, or harsh punishments for theft, even if someone was stealing because they were starving.
Precisely those kinds of laws. The source argues these laws, which he claims have persisted in various forms for hundreds or thousands of years, have one main purpose: to maintain the monopoly of land and wealth held by the lawmaking slaveholding class, and to keep the vast majority of laborers poor and dependent. This dependency forces them to sell their labor for whatever low price the owners offer.
So he concludes pretty sharply on this.
Very sharply. The text concludes that the entire business of legislation, historically, originated in conspiracies among the few for the purpose of holding the many in subjection and extorting from them their labor.
So in the view presented in this source, the basic motive behind legislation hasn't really changed over time, even if the forms look different.
According to Spooner in this text, no. He states, the whole purpose of this legislation is simply to keep one class of men in subordination and servitude to another.
He defines legislation itself in pretty extreme terms then, doesn't he?
He absolutely does. The source defines legislation fundamentally as an assumption of absolute, irresponsible dominion over all other men. It's presented as someone claiming the right to just abolish other people's natural rights, make them slaves, dictate every aspect of their lives arbitrarily, and basically banish true justice, replacing it with the legislator's own personal will, pleasure, and interest.
Oh, cool.
This whole assumption, the source states, is just inherent in the very idea of human legislation having binding authority, which makes it, in his view, the polar opposite of natural law.
There was also that note included in the source about Judge Sir William Jones. What does that add to Spooner's perspective here?
Right. The note quotes Judge Jones saying that pure, unbiased reason seldom fails to draw the same conclusions in such juridical inquiries as are not fettered and manacled by positive institutions.
Okay, what does positive institutions mean there?
Spooner interprets positive institutions to mean human-made laws, legislation. So he reads Jones as saying that judges, when they rely solely on reason and aren't bound by existing statutes, tend to agree on what justice actually requires. This reinforces Spooner's core argument. Justice is inherently understandable through reason, but it's human legislation that often confuses things, gets in the way, or actively violates it.
Okay, let's try and pull this all together then. Summing up the argument we've explored from these Spooner excerpts. On one side, you have natural law. He describes it as the simple, intuitive, unchanging science of justice and rights, discoverable by reason, and for him, the only actual basis for peace and order.
Right, that's one side of the coin. And on the other side, you have human legislation, which he argues in this text historically started with force, conquest, by basically criminal gangs. He claims it's based on arbitrary will, not justice. It seeks to dominate people, and ultimately it's presented as a tool for one class to control and exploit another class, fundamentally replacing real justice with the whims and interests of lawmakers.
It's a really powerful and definitely provocative contrast he draws in this text. So why is grappling with a perspective like this important for you, the listener, even if it feels, radical or challenges your own views about law and government?
Well, doing this deep dive into Spooner's text, it offers you a completely different framework, a different lens, for looking at the systems and laws that shape society. It really pushes you to ask some fundamental questions. Based on this source material, what is the actual basis of law? Is it some inherent principle or just human will? Where does authority really come from? Are the laws we live under necessarily just? Or could they be, as Spooner claims here, primarily instruments of power and control?
Right. Is justice something humans create or something we discover that already exists?
Exactly. It highlights the argument from this source that what we routinely call law might actually be, from his perspective here, the very opposite of true natural justice.
So we've taken this deep dive into Lysander Spooner's very sharp distinction, as presented in these excerpts, between natural law and human legislation. We've explored his claim that justice is the simple, intuitive, immutable science that defines our inherent rights, and contrasted that with his view of legislation as historically originating from and continuing to serve the purpose of control and exploitation, substituting arbitrary will for real justice.
Yeah, the source material definitely presents a challenging viewpoint. It suggests that much of what we just accept as law might actually be a significant departure from a more fundamental natural justice.
Yeah.
A justice, he argues, is easily understood by almost anyone.
It really leaves us with something significant to think about, drawing directly from these texts. If justice truly is this simple, intuitive principle, something graspable even by children, as he claims, what does it say about the complex systems of human legislation we've constructed when, according to Spooner here, they seem to clash so often with that simple, natural justice? What stands out most powerfully to you from this exploration?